Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
Suppose you were a nurse hired on a probationary basis, but before the 6-month period ended and despite obtaining passing marks, you were fired by the hospital. Can you claim illegal dismissal? And up to what extent can you claim back wages? Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 13th of December 2024, and today we talk about the case of CP Reyes Hospital and Angelina Reyes versus Geraldine Barbosa, decided on April 16, 2024. It's an en banc decision penned by Supreme Court Associate Justice Antonio T. Co. Jr. And joining us to talk about this case is Attorney Philip George Bacani from the Office of Associate Justice Co. Hi, Attorney Philip. Thanks for joining us and welcome to the Supreme Court Podcast.
Good day, Attorney Mike. Thanks for having me.
All right, so Attorney Philip, this is an illegal dismissal case. Tell us first, who is Geraldine Barbosa and what's her basis for filing the case?
Geraldine Barbosa was hired by CP Reyes Hospital as a training supervisor for nurses. In her contract, it was stated that she would be hired on a probationary basis for 6 months, and she would be graded on the first, third, and fifth month of that period. And to qualify for regularization, she was told that she would need an average grade of 80%. However, on the second month of her probationary period, the hospital informed her that she would not be regularized. A month later, she was formally dismissed from the hospital.
Right, so what were the defenses raised by CP Reyes Hospital? Why did they dismiss her despite getting an average grade of 80%?
Right. CP Reyes Hospital raised two defenses. First, they said that Geraldine allegedly failed to qualify for regularization because she demonstrated poor time management skills, she lacked initiative, and she did not get along with her colleagues. She was also unable, allegedly, to familiarize herself with basic nursing procedure. And then they also said that she supposedly incurred 13 absences in her 2 months with the hospital.
So this case went to the labor arbiter. How did the labor arbiter rule on Geraldine Barbosa's complaint?
The labor arbiter sided with Geraldine and ruled that she was illegally dismissed. It took note of the grades that Geraldine received during her 2-month stint. And as you said, she achieved 80% or more during that period. And the labor arbiter found that her grades qualified for her to continue the probationary period.
And was this ruling by the labor arbiter affirmed by the National Labor Relations Commission?
No, the NLRC reversed and found that the dismissal was legal. According to the NLRC, the labor arbiter should not have solely considered the grades that were given to Geraldine. It should have also read the feedback and written evaluation that were given by Geraldine's evaluators. If it did, then it would have found that they were not satisfied with her performance at all, despite the grades that were given to her.
So you have the NLRC reversing the labor arbiter. When this went to the CA or the Court of Appeals, how did the Court of Appeals rule?
The Court of Appeals agreed with the labor arbiter. CP Reyes Hospital violated its own policy of reviewing probationary employees on the first, third, and fifth months, and it fired Geraldine just 2 months into her employment. It also agreed that even Geraldine's evaluators gave her passing marks during her 2-month period, which contradicted the claim of the hospital that she failed to qualify. Then, it also held that Geraldine could not be guilty of absenteeism because most of her supposed absences occurred even before she was employed, and the ones that happened during her employment were either explained reasonably and covered by applications for leave, which the hospital granted.
So Geraldine won at the Court of Appeals level, so that's why this case is entitled The Hospital versus Barbosa, because it was the hospital who went to the Supreme Court. How did the Supreme Court rule on the basis of the merits of this case?
Mainly, the Supreme Court affirmed the Court of Appeals. It held that Geraldine, a probationary employee, was illegally dismissed by CP Reyes Hospital.
So, Attorney Philip, let's try to break down the ruling of the court. Barbosa was declared a probationary employee. Let's try to explain first, what is a probationary employee? How is it different from a regular employee?
Right. So the labor code recognizes two kinds of employment in this case: so probationary employment and regular employment. Probationary employment are those covering employees who are made to go a test or a trial period, what's called the probationary period. It's an opportunity for the employer to see the fitness and skill of the employee before qualifying them for regularization. Now, regular employees, on the other hand, have either completed their probationary period or are hired directly as regular employees. They are entitled to benefits under the labor code as well.
So that 6-month period is really a chance for the employee to prove himself or herself that she is fit for that role.
Yes, the employer is tasked with informing the employee at the start of the period what standards they should meet and how they should perform before they are regularized.
Right. So in Geraldine's case, what factors did the court consider to determine her status?
Well, first of all, it was important for the court to determine Geraldine's employment status, whether she's probationary or regular. It's because Geraldine insisted in her complaint at the start of the case that she was a regular employee who was made to sign a probationary employment contract. She said that the CP Reyes Hospital basically forced it upon her, or she was made to sign the contract. However, looking at the contract itself, the court found that it was clear that there was a probationary period of 6 months, and even Geraldine's arguments before the labor arbiter indicated that she knew it was probationary and she accepted the terms anyway. So the court really took note of the admissions of Geraldine and the contract itself.
But the court also declared that she was illegally dismissed. Can you explain this to us? She's a probationary employee, but she can be considered to have been illegally dismissed.
Yes, the court took note of the arguments of CP Reyes Hospital. Basically, the grounds that they relied on to dismiss her are: number one, she failed to qualify for regularization, and second, that she was guilty of absenteeism. On the failure to qualify for regularization, the court held that instead of relying on the grades, on the passing grades, CP Reyes Hospital relied on outside feedback or evaluation, or the written evaluation of her superiors, where it was stated that Geraldine had poor interpersonal skills, that she needed to refamiliarize herself with routine and common nursing procedure. To CP Reyes Hospital, it shouldn't just be the numerical grade that determines the regularization. It claimed that it also can rely on the feedback from her evaluators. The court rejected this argument because, to the court, the grades given to Geraldine should determine her prospects for regularization. And then on the issue of absenteeism, the court agreed with the CA that her absences were either incurred even before she was employed, number one. Number two, that she wasn't absent at all on some of the days that she was claimed to be absent. And third, that her absences were explained by appropriate and approved applications for leave.
So hang on, Attorney Philip. You said some of the absences were even before she started working?
Right. In her contract, it was stated that she was supposed to start on September 4. However, in the charge of absenteeism, they claimed that Geraldine was absent on September 1 and September 2, which was outside her employment period.
Interesting. Now, there was a significant discussion here in the case between Geraldine obtaining the 80% passing grade and her supposedly not qualifying in terms of the other factors that the hospital relied on. How did the court make sense of the seeming disconnect?
First of all, Attorney Mike, ordinarily the court only rules on questions of law, which means that it only applies what the law is to with regard to an established set of facts. However, here, the Court of Appeals and the NLRC differed in their rulings. So that allowed the court to review the evidence in order to resolve the issues raised. With regard to the grades she received, the court found that indeed Geraldine obtained grades above 80% in her 2 months with the hospital. The records showed that CP Reyes Hospital used a highly specific personal evaluation form containing around 50 plus items on which Geraldine was to be graded. Despite passing these criteria, Geraldine still supposedly failed to qualify because of other factors, which the hospital cited are her interpersonal skills, her absences, and her supposed lack of knowledge of basic nursing procedures. So the court looked at these other factors and found that they were in the criteria stated in the evaluation form. For instance, her nursing skills, her interpersonal skills, and her nursing knowledge, these are all already in the criteria for which she was supposed to be graded. And she passed her evaluation.
So in short, because of the grade she obtained, that should have meant that all these other factors were irrelevant already because she passed in terms of the grade, and they were already included in the grading
Yes.
of her performance.
Yes, attorney.
Right. Right. So what should be the guide in illegal dismissal cases involving probationary employees? Should the rule that the reasonable standards for qualification should be communicated to the employee at the time of engagement, should it apply all the time?
The general rule is yes, at the start of probationary employment, the employer must inform the employee of what standard they will use or they should meet in order to become regular employees. This gives the employee an opportunity to know how they should perform and what they must attain in order to become regular. However, there are exceptions. First, in the case of self-descriptive positions, this was laid down in jurisprudence in positions such as cook or driver or messenger. There is no need to explicitly communicate the standards for regularization because the position is self-descriptive in nature. Second, jurisprudence also recognizes that the employer is not required to communicate matters of basic knowledge and common sense. Like, for example, you need to be at work on time or you need to respect your colleagues. These matters are already deemed included in the standard of behavior that employees must meet.
So in Geraldine's case, did the court say she was properly informed of the standards? Was there a deviation from that? Was there a violation of her due process?
The court found that Geraldine was actually informed of the standards that they must meet. The personal evaluation form was given to her at the start of her employment. It was actually CP Reyes Hospital's supposed deviation from these standards that are the issue. It claimed that aside from the evaluation form, they can fire her for other grounds as well, which the court rejected.
Right. Right. So what about the argument that Geraldine was always absent? Was there basis to support this claim?
There was no basis to support this claim. Actually, as I mentioned earlier, this was among the factual issues that the court looked into, and the court found that based on the evidence presented, there were several supposed absences attributed to Geraldine. The first ones were absences incurred even before she was employed, which was illogical. Number two, she was also charged with being absent on days when she was part actually of the skeletal team. So she was present. And there were also other absences for which she filed an application for vacation leave, and that was granted by CP Reyes. There were 3 remaining absences where Geraldine was not able to explain her absence. And for that, the court, in affirming the CA, held that the CP Reyes Hospital failed to first inform her and ask her to explain these absences, and instead went and directly dismissed her.
Mm-hmm.
So this was a violation as well of her procedural due process rights of being informed of the charge against her and answering them before being terminated.
No, all right. Now that the illegality of her dismissal was clearly established, how do we determine now what an illegally dismissed employee is entitled to?
It's clearly stated in the labor code that illegally dismissed employees are entitled to reinstatement without loss of seniority rights and other privileges, full back wages inclusive of allowances and other benefits that were withheld from them up to the time of their actual reinstatement.
Can the employer say, sorry, reinstatement is no longer possible?
It can, but the issue of whether reinstatement is no longer possible does not depend solely on the say-so of either the employer or the employee. The Supreme Court has held in several cases that it must be established by the evidence that the relationship between employer and employee has been damaged to such a degree that it is no longer practical or feasible for the employer to accept the employee and for the latter to return to work.
So in that case, what can the employee claim?
In case reinstatement is no longer feasible, the employee is entitled to separation pay in lieu of reinstatement.
Right, and of course, there's back wages. But a question here, Attorney Philip, is in computing the back wages, what's the reckoning point for the period covered? Should we start with, the period when you were informed you're being dismissed, or from the time when the back wages or the wages were withheld from you?
This was actually one of the issues answered by the court in this case. The Court of Appeals, in its decision, awarded back wages to start when Geraldine was terminated, which is in November 29, I believe. However, the court found, based on the evidence presented, that Geraldine received her pay from December 1 to 31st. So, based on jurisprudence, back wages should be computed from the time compensation was withheld, which was on January 1, 2014 already. So, yeah.
On the other hand, until when should back wages be computed for illegally dismissed probationary employees? Should it be until the finality of the decision, as Chief Justice Alexander Gismundo argued, or until the end of the probationary period, according to Associate Justices Alfredo Benjamin Caguioa and Ami Lazaro Javier?
Well, the general rule is that back wages is computed from the time the pay was withheld until actual reinstatement. Now, in case reinstatement is no longer feasible, as the case here, then back wages is computed until the finality of the decision that found the dismissal to be illegal. The court considered the arguments raised by the Chief Justice and Associate Justices Caguioa and Lazaro Javier in their respective opinions and held that computing back wages from the date of withholding pay up to the finality of the decision is consistent with the constitutional and statutory policies governing labor. This is the applicable computation for illegally dismissed regular employees. And to the court, neither the Constitution nor labor laws made a distinction in case of probationary employees.
So it's interesting to note, Attorney Philip, that Associate Justice Benjamin Caguioa actually pointed out that in so ruling, the court was actually overturning an existing precedent at that time and reverting to a previous case.
Yes.
So this is quite significant in that respect. What's the explanation? Because Justices Caguioa and Lazaro Javier are saying, for a probationary employee, you're only secure up to the extent of the probationary period. But here, the court is saying, no, you're protected like a regular employee, even if you're a probationary employee.
Yes, in considering the arguments of Justices Caguioa and Lazaro Javier, the court noted that a probationary employee is allowed to work until the end of the probationary period. Now, at the end of that probationary period, it is up to the employer to decide whether they qualified for regularization. However, in this case where the probationary employee was terminated legally before the lapse of the period, the court held that had it not been for the illegal termination, then the probationary employee would have continued employment. It would have logically reached that point where they would be graded and they would be considered for regularization. And even possibly, if they are allowed to work even beyond the probationary period, then they are already considered regular under the law. So to the court, it's not really the employer-employee relationship is not severed just because the probationary period ended.
Okay, so so employers may now have to think twice before dismissing someone on probationary status because they risk having to pay for back wages until the finality of decision, and we don't know when that would be. Attorney Philip, do I take it that it is riskier now for an employer to hire someone on a probationary status and dismissing that person at the risk of later on paying back wages up to the finality of the decision?
I wouldn't characterize it as risky because there is nothing in this decision with regard to probationary employment that is not already laid down by the law. First of all, in probationary employment, the employer has the duty of informing the employee of the standard that they must meet, first of all. And second, that it falls on the employer to fairly grade their probationary employees at the end of the probationary period and not rely on arbitrary or unreasonable grounds to dismiss them. This has been laid down by jurisprudence and the law as well. So the key takeaway, I suppose, is that the employers should be mindful of dismissing probationary employees, and they have to keep in mind their own standards. They are free to lay down their own standards for dismissing or regularizing employees, but they must stick to those standards as well, of course, to be fair to their probationary employees.
Right. Yeah. Very interesting discussion. Thank you very much, Attorney Philip, for joining us today.
Thank you, Attorney Mike.
And if you wish to read the full text of the court's decision, you can go to the Supreme Court website and e-library. Just search for C.P. Reyes Hospital and Angelina M. Reyes versus Geraldine M. Barbosa, GR number 228357, April 16, 2024. Here's Tiff Atendido Beltran, Supreme Court Information Officer for this week's Roundup.
At the Supreme Court this week. The Supreme Court held that the bar examination scores of individual bar takers are sensitive personal information under the Data Privacy Act. Thus, they cannot be disclosed without the prior consent of the examinees. In Bar Matter number 4968, the SC En Banc approved the guidelines on requests for disclosure of a law school's bar examinations performance. Under the guidelines, the SC may approve requests from law schools for bar exam scores as long as these scores are aggregated, averaged, or anonymized and do not identify any individual bar exam taker. In another decision, the Supreme Court underscored that a writ of mandamus may not compel the Commission on Elections, or COMELEC, to exercise its discretion in a certain way, such as granting or denying a request to open and recount ballot boxes. Mandamus is an extraordinary writ that compels a person, tribunal, corporation, board, or officer to carry out a legally required action if it has failed or refused to do so. This action must be ministerial, meaning that its performance does not involve the exercise of discretion or judgment. In dismissing the petition, the Supreme Court held that the issue did not involve a ministerial act by the COMELEC, as the requested recount of physical ballots requires the exercise of the COMELEC's discretion and judgment. It also ruled that petitioners failed to establish any clear, complete, and specific legal right to a recount. Nevertheless, the court found that the COMELEC was guilty of official inaction when it acted on the motions beyond the period prescribed by its own rules. The Supreme Court, in partnership with the Philippine Judicial Academy, or PhilJA, held its first human rights symposium titled Rethinking Adjudication in a 21st Century Democracy, Symposium on Contemporary and Enduring Challenges to the Philippine Judiciary on Questions Involving Freedom of Expression, on December 10 and 11, 2024, at the Philippine Judicial Academy, Philippines, in Tagaytay City. The 2 day symposium focused on the fundamental freedoms of speech, expression, and of the press. The protection and enforcement of human rights in the Philippines has always been among the court's core priorities and is consistent with the guidelines of its Strategic Plan for Judicial Innovations 2022 to 2027, or the SPJI. The event coincided with the celebration of International Human Rights Day, which is commemorated on December 10 of each year. The Supreme Court also conducted the Office of the Regional Court Manager Information Dissemination and Recruitment Drive on December 10, 2024, in Tagaytay City. Senior Associate Justice Marvic MVF Leonen gave a briefing on e-court, while Court Administrator Raul B. Villanueva discussed the ORCM. On December 11, 2024, the Supreme Court Public Information Office held the SC Meets the Press, an official media gathering similar to a press briefing. Chief Justice Alexander G. Hesmundo, Associate Justices Rodil V. Zalameda, Samuel H. Gerlan, and Jose Maidas P. Marquez answered queries on court-related matters from the media. In a message delivered on his behalf by SC spokesperson Attorney Camille Sue May Elting, Chief Justice Hesmundo expressed gratitude to the media, quote, for being our steadfast partners in sharing the stories of the judiciary with the Filipino people, end quote. He likewise highlighted the judiciary's significant achievements for 2024, starting with adjudication of cases as follows. As of September 30, 2024, the Supreme Court disposed of 4,294 cases with a case disposition rate of 22%. As of November 30, 2024, the Court of Appeals disposed of 14,699 cases with a case disposition rate of 35%. The Sandigan Bayan disposed of 994 cases with a disposition rate of 44%, while the Court of Tax Appeals disposed of 648 cases with a disposition rate of 29%. For the lower courts, they disposed of 508,197 cases for a disposition rate of 43%. Chief Justice Hesmundo also gave an overview of reform programs aimed at enhancing the delivery of justice under the Strategic Plan for Judicial Innovations 2022 to 2027, or the SPJI. On December 12, 2024, the Supreme Court and the Philippine Judicial Academy launched the Kalesa Digital Program, a follow-through of the Kalesa project. Funded by the European Commission and implemented between January 15, 2024 and January 14, 2024, a successful collaboration between European and Philippine universities, which, among others, aim to enhance academic research capacities and strengthen cooperation links between the pertinent academic institutions. On December 13, 2024, the Supreme Court released the results of the 2024 bar examinations. Bar Chairperson Associate Justice Mario V. Lopez announced that 3,962, or 37.84%, successfully passed the bar. Kyle Christian G. Tutor of the University of the Philippines topped the 2024 bar exams with a grade of 85.77%. And that's your Supreme Court this week. I am Tiffany Dobletran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Jen Tuazon Eranya as researcher, Victor Naranjo, Brian Austria, and Don Ryan Balza as sound editors, and Tyke Flores and Jerome Batumalake as web editors.